Hello, my name's Joanne Kawolski, and it's my very great pleasure to introduce some of the definitions we'll be working with during the Global Pound Conference series. We hope that this will help to clarify the choices that exist when shaping the future of dispute resolution and, of course, improving access to justice more generally, the thing that unites us. I'm not a lawyer, I'm a consultant, and I work in conflict resolution and with judges. My academic background, unusually for a mediator, is in languages and literature and in adult education. I've also worked for immigrants and refugees and as Community Relations Director for the Anti-Discrimination Board in my country, Australia. I've also been a practicing mediator and mediation trainer since 1990, and I've mediated large multidisciplinary, multi-party disputes, Indigenous land claims, environmental matters, public infrastructure projects, as well as industrial and academic disputes. I've also been a member of two tribunals, the Federal Administrative Appeals Tribunal and the National Native Title Tribunal. So I have experience in conciliation and adjudication as well as in mediation. The judges I work with are very concerned with pressures of cost and time, language and culture. And I offer them new perspectives as well as approaches and skills, and together we wonder aloud about the future of the justice system and access to it. Each dispute resolution process, as you know, offers something different. But do disputants know and understand these differences? And how can we better harness these differences to select the most appropriate course of action for particular disputes? That's one of the topics I believe the Global Pound Conference to be about. Bernard Mayer, the author of The Dynamics of Conflict Resolution, famously said that what makes a successful peacemaker or conflict resolver is not a set of processes, methodologies or tactics, or not alone. It's a way of thinking, a set of values, an array of analytical and interpersonal skills, and a clear focus. David Plant, another great American arbitrator and mediator, used to say, we need to approach the process as part of the problem. So let's first look again at those processes. I'd like to take a moment to introduce the Global Pound Conference series because there are going to be some key words and concepts, and they're going to be hotly debated, I imagine. The first, of course, is what is justice? The second, what makes it accessible? And the third, what's an appropriate process in a given context? Sir Lawrence Street, a judge and the champion of mediation in Australia, once said as he looked around his law book-lined, beautiful office, there must be a better way. Half of all these people lost. I think our goal is to try to do better than that. The Global Pound Conference series is going to need some common definitions. Why, I hear you ask? We all hate definitions. Because one Dutch publication shows 60 different definitions of mediation in 60 states. So I think we need to distinguish litigation and arbitration, which are adjudicative procedures, from mediation and conciliation, which are essentially consensual. Even if the definitions today may be called something else in your country, and even if you have strong feelings about what defines certain processes, we ask that each conference use this terminology for the sake of clarity during the event so that there can be a chance of comparability. The next few slides are provided to assist in explaining those differences and the differences between the processes shown in this slide and why there's a broader range of choices than simply negotiation or litigation. Litigation and arbitration are both adjudicative processes. This means that any solution is based on a decision made by a neutral expert, for example, a judge in a court or tribunal, or an arbitrator. The main differences between arbitration and mediation are that the parties can choose one or more arbitrators and have their own private decision maker, whereas in a court-based procedure, in litigation, They have no such choice. The parties can adapt the rules of procedure in arbitration by mutual consent, whereas this is impossible in litigation. Decisions by a national judge in litigation are subject to appeal, whereas there are only very limited grounds for appeal in arbitration, and it may be that you think that's no good thing. One of the advantages of arbitration over litigation is that arbitral awards tend to be easier to enforce internationally due to an international convention, the New York Convention of 1958. National court judgments are generally harder to enforce abroad and may be subject to appellate review. Both arbitration and litigation are based on objective justice, in the sense that the outcome is based on norms or findings of fact and law made by the arbitrator, the judge, or the tribunal. Arbitration and litigation involve an analysis mainly of what happened in the past and not, or less so, of the parties' interests in the future. Adjudicative processes are competitive in that each side needs to convince the tribunal that they are right, and of course that the other party, the other side, is wrong. Take a look at conciliation. It starts off by resembling arbitration or litigation in that an expert is appointed who's able to provide an opinion and to act in an evaluative manner. The difference, however, is that the recommendations made by the neutral, called a conciliator in this process, are non-binding, unlike a judge or arbitral tribunal who impose the final decision. The conciliator is normally an expert, a person who knows the law but will not impose an outcome. Conciliation is a consensual process in that a final settlement is only binding if both parties accept it. Conciliation, moreover, is an evaluative process, often very evaluative. The expert may advise the parties what would likely happen if the case were to go to trial or to arbitration. And the expert is in a position to advise on aspects of the law as it applies to the dispute. The conciliator looks at the precedents and the applicable law, assesses the parties' arguments and positions, and, depending on their assessment of the law and the relevant facts, creates a zone of possible agreement based on these parameters. And within those, the parties can locate a settlement to their dispute. The conciliator as well is an active participant in discussions and very much in the search for solutions. Conciliation is therefore a form of objective justice, insofar as it's based on norms. The conciliator can make a settlement proposal once he or she has heard the relevant facts and the law. Like arbitration and litigation, it's likely that the parties will try to convince the conciliator that his recommendations should confirm their views of the case. It's a consensual but also competitive process in that each party tries to convince the conciliator to give a non-binding analysis of the dispute that is quite naturally in their favour. Look at the last slide. It's about mediation, a consensual process par excellence. The mediator is not the decision maker, unlike in arbitration and litigation. Mediation is different from conciliation, litigation and arbitration, however, in that any outcomes are based on what the parties are willing to do, without any pressure from the neutral. Ideally, a mediator is not evaluative. He or she does not seek to use any findings of fact or law to create a zone of possible agreement based on what a court or tribunal might decide, although some of those aspects may enter the discussions. Instead of looking at the facts or the law, the mediator allows the parties to focus on the future as well as the past, and to find solutions based on their interests as opposed merely to their positions, though of course positions play a key role. In some civil law countries, mediators are not allowed to make a settlement procedure, a proposal. It's a process that looks at the parties' future interests more than the past facts or the applicable law. Mediation is also much more inclusive as all interests can be taken into account, such as feelings, concerns, desires, relationships. Nothing is by its nature considered irrelevant. That makes mediation a very powerful process. In mediation, the solution is not driven by what a court or tribunal would likely found, though that can also influence the parties' search for a solution, and frequently does. Mediation is thus a form of subjective justice, in that it can take into account the parties' interests, concerns, hopes and desires, as well as their emotions and their social relationships.